Thank you. Welcome, everybody, to House General and Housing. It is Tuesday, March 25th, 2025. What we're going to do this afternoon is first, we're going to hear from the sponsor, and then we're going to have a walkthrough of H334, which is an act relating to limiting employer restrictions on individuals separating from employment. And then we're going to have a walkthrough and a possible vote on a bill which we've had introduced before. We'll have an amendment, and that's H106, which is the one about selling real property in flood zones. And then we're going to talk about our presentation on the floor tomorrow of the housing bill, because that's when it's coming up, is tomorrow. My advice generally would be to be prepared to be here a little late tomorrow when I look at what's going on. So let's start with H334. Kate, you want to introduce yourself and take it away? And then Sophie, our ledge counsel, Sophie Zatney, is here and she will do a walkthrough.
Hi all, I'm Representative Kate Logan. I represent the Chittenden 16 district. That's Central Old North End and downtown Burlington. I serve on the Committee on Environment, and thanks for having me here today to introduce H334. This is a bill on a couple of issues that you might have heard in the news. I've personally received email regarding both of these issues from constituents or just folks in Vermont. And a number of bills have been introduced across the country, and these provisions have been passed in the state law in a number of states. And I hope that Legislative Council can give you a little bit more context on how other states have approached these issues. There are two primary problems that this bill tries to solve. The first is the use of non-compete agreements by employers to prevent staff who leave their role from going into a similar role with another employer after leaving employment with them. There are a couple bills related to this issue that have been introduced this year, one more narrowly focused on certain sectors. This is broad and just be a general addition to our employment laws in Vermont. And let's see. And then the second problem that this bill tries to address is
Hey, if I can interrupt.
Yep.
You say that is the other bill active, like in the Senate, or has it been introduced here? Do you know?
It has been introduced in the House, as far as I know, and I believe it's in the Healthcare Committee.
Okay.
I have not been following it closely.
Okay.
Because it was related to certain fields, certain healthcare fields in particular. Of course, the second part here is about stay or pay provisions. So these are agreements where an employer, as a condition of employment, requires that an employment pay the employer upon separation from employment. So often what that looks like is if you're provided training in order to take a job, but you leave, then you have to repay the employer for that training if you leave within a certain period of time. Or if you leave a job, if they offer, say, like a tuition benefit, you take advantage of that benefit and then you leave the job, they ask you to pay them back for that tuition benefit, just actual fees to leave your job within a certain period of time, or asking for you to return a sign-on bonus if you leave employment. All tied to a mandatory period of employment. So if you leave before that period of employment, that you agreed to, then you have to pay your employer back. So this, would make that an unlawful employment practice. And then there are a list of things that would make that not an unlawful employment practice. So a bunch of conditions that would further refine the requirement.
Questions for Kate? Go.
Yeah, I guess just for the second part of it, the stay or pay provision part. Is it your intent for, say, like a hospital to pay for the college tuition for, say, an LNA to get their RN, but it comes with a condition of 2, 3, 4 years? Would that be something that'd be illegal under this?
So I think it's helpful, we should just go ahead and review this section here on page 5, where it talks about what makes a stay or pay provision not an unlawful employment practice. So it's not unlawful if the employee voluntarily agrees to the provision in exchange for a benefit. The repayment amount is reasonable and does not exceed the cost to the employer of the benefit received by the employee. The repayment amount is specific and provided to the employee before the employee agrees to the provision. The length of stay period associated with the provision is reasonable based upon a number of factors, including the cost of the benefit, the value of the benefit to the employee, and whether the repayment amount decreases over the course of the stay period, et cetera.
Perfect. Sounds like that'd probably be just fine then.
Yeah, right. Yeah,
Thanks.
it's not meant to ban it outright per se, but to just put some guardrails.
Guardrails. Yeah.
Other questions of Kate? Kate, I have a question. I don't know anything about these provisions, the stay or pay. Are they triggered when people are fired or only when they voluntarily leave?
That's a good question. I believe it is when
Or
somebody
terminated?
voluntarily separates from employment.
I would hope so.
Actually, though, now I'm rereading the bill. Oh, no, voluntarily or involuntarily separates from employment.
Hmm.
Yeah, so apparently,
So maybe there are provisions that deal with that actually contractual provisions that have you pay back even if you've been terminated. But who knows? I was just wondering if the.
that's a great
practice out
question,
there-
though, and that was not what I was concerned about when having this bill drafted, so I would be very interested to hear what legislative council would offer.
Mary?
Thank you. Isn't there something already in an agreement if you agree to pay tuition? Let's say Representative Parsons' example, you pay for someone to be an RN. Isn't there some sort of an agreement already established that if you leave within a certain period of time, then you must pay back? So,
That's what this is putting guardrails up around. So it's saying if you're going to have a stay or pay provision, if you're going to have somebody sign one, then it can't, they can't, basically they can't consent to that unless it meets these guidelines. And it has to be, I think the most important ones here are, oh, wait, no, it says the provision does not require repayment if the employee is terminated without cause. Okay, like I just haven't reread the bill carefully enough recently.
Actually, I was just asking, not what's in the bill, but what's out there in the.
Oh,
I
yeah,
was just wondering if these agreements
yeah,
would make you pay back if you were terminated without cause.
I would imagine that there are, yeah. But in particular, I think these guardrails here on page 5 say that you can do that, and some of those might be fair contract terms, but there are no legal requirements that the terms be fair in law. So right now, it's up to the person signing the employment contract the employee to determine whether or not the terms are fair and then decide whether or not they'll sign. But here, so we're trying to, in state law, say, can't make it an unreasonable payment back to the employer. It has to be proportional to the benefit. It should decrease, the amount that you have to pay should decrease over time, over the length of employment. So let's say you did pursue an RN as an LNA, and then they have an employment term of 2 years where you have to work for them as an RN, but for reasons maybe even beyond your control, you leave up at, before 2 years, then how much you would have to repay the employer should be reasonable and shouldn't reflect how long you've worked for the employer. So this is not particularly radical, I would say. It's really just trying to make sure that there are standards in place.
Any other questions, Kate? Thank you so much. Really appreciate your coming.
Thank you.
Sophie, would you like to come up and walk us through this bill? And if you have any background to give us about these kinds of provisions, we'd appreciate it.
Want background first or walk through the bill first?
Well, why don't you start with background?
Great.
Consider this background.
Yeah, so as noted, there are other states that have a handful of other states that have complete bans. I'm going to talk about the non-competes first. So there are some states that have complete bans on that. Just get those two for you. Except I've lost my note. So complete bans, California, Minnesota, Nebraska, North Dakota, and Oklahoma. And then there are a number of states that have wage threshold or notice requirements. So I'm just going to run through the Maine, New Hampshire, Massachusetts, Rhode Island, Maryland, Illinois, Colorado, Nevada, Oregon, and Washington. I did take a closer look at the ones that are closer to us. So New Hampshire, and again, these are agreements not to compete. They must be reasonable in duration, geographic scope, and activities that are prohibited. There's a wage threshold, so they're banned for employees that earn an hourly rate less than or equal to 200% of the federal minimum wage. A notice requirement that employees must be provided a copy of the agreement prior to accepting an offer. And then they have, again, for specific professions. So they're banned for physicians and podiatrists in New Hampshire. In Maine, same thing, reasonableness requirements, reasonable in duration, geographic scope, and the activities that are prohibited. The wage threshold in Maine is, and the employee must earn at least 400% of the federal poverty level. And again, the notice requirement, the employer must disclose prior to making the offer that the non-compete will be required and provide a copy of the non-compete at least 3 days before it is signed. And then they have exceptions. So again, no non-competes for broadcast employees and veterinarians. Massachusetts.
What?
You can tell he's got strong advocacy groups. So Massachusetts, again, must be reasonable in duration, geographic scope, and activities prohibited. They have a limit of 1 year. So there are some limited exceptions to that, but generally limited for 1 year. No threshold, wage threshold. Again, you must notify the employee of the right to consult with counsel before signing, and you need to give them time up to 10 business days before their start date, etc. And they also, non-competes are banned for non-exempt employees. So those are hourly employees, broadcasters, physicians, nurses, social workers, psychologists, student interns, short-term student employees, and employees under the age of 18. And then the other one I looked at was Rhode Island. Again, similar, their wage threshold is 250% of the federal poverty limit. And they also have exceptions for non-exempt employees or bans for non-exempt employees, student interns, and young employees and certain medical professions. So, that's just general background on where the state of the law is on those. This particular bill, again, there's two,
Sophie, if I can ask.
yeah,
I mean, this may just, it may be something you don't know, but on the other hand, I know you have a lot of employment experience. It's in states which have a total ban, like let's say California. I'm just thinking, what do employers who are dealing with people who acquire really specialized knowledge that's very valuable, what do they do about that? And I'm wondering, in those kinds of states, do we see non-disclosure agreements with damage provisions or something like that instead?
yeah. So for example, Minnesota was one of the states that we looked at that has a complete ban. But again, there are going to be limits on what those are. So again, there, just as in this particular bill, there are certain things like, so for example, it specifically says, defines an agreement not to compete as not including agreements that prohibit disclosure of trade secrets or confidential business information. And it also would not prohibit non-solicitation agreements. So non-solicitation agreements. So if you leave, you can't then solicit the, people that you were working with, your employer's clients.
Right.
So again, this is not a outright ban. This is more restriction, just sort of a general prohibition, but then there are a lot of exceptions to it to provide that flexibility.
So you could go to work for a competitor or form a competing organization, but you'd have to be really careful not to use the knowledge that you acquired or be subject to litigation.
Right.
And you couldn't turn around and solicit
Use their client list.
all the buddies that you worked with and ask them to come with you.
Right.
Okay, thank you.
Sometimes.
Go ahead, please, both of you guys.
Mary, go first.
Go for it.
Sometimes there are limitations, in the area,
Right. That's the geographic.
the
Yeah.
geographic. I know of a physician that had his own practice and then joined a group and left that group and was looking for other locations. And there was a non-compete, I believe, in a certain area. And so then he ended up moving out of state.
Right. Right. So I mean, just generally under Vermont law right now, just through case law, again, just some of the things we've already discussed, but typically the court looks at trying to balance the interests of the employer and the employee. But generally, they're going to look whether a non-compete is narrowly tailored in terms of geographical, temporal, and subject matter restrictions to protect the employer's legitimate business interests. So that's the current state of the law by case law in Vermont. So this would put into statute some of those same provisions.
Sonia.
Thank you. So just clarifying question, just so for unintended consequence purposes. If someone, say, left a job, but they didn't. Like, 'cause in Vermont, it's small state, right?
Right.
Especially in some rural areas. So if the clientele, they didn't poach the clients, but the clients went with them, they would have to refuse those clients.
Usually in litigation, it's going to come down to a really fact-specific determination. There would be, inquiry into, how the clients came to transition over,
So that's up for the conversation.
Yeah.
This wouldn't affect. This wouldn't affect, like, that would, and current statute is like, that's not going to impede anything in the event of those, that there's processes for that.
Well, what this statute would do would be to limit the kinds of non-compete agreements that you can have. So if this were to become law, then, you'd have to, again, was there a non-compete agreement? But generally speaking, right now, that's when litigation results is someone leaves and takes, the number one client, the biggest client of their former employer or whatever it may be, and that's when you land up in
Yeah.
litigation.
Yeah, I mean, if the client says, you never asked me to leave, I just
Yeah.
don't like all the other people and like her. I'm gonna go with her.
Yeah,
That's different than that kind of thing, but that's not affected
that's
here.
not affected here. Okay, thank you, sorry.
So take it away. Want to walk us through?
Okay. So again, what this bill would do would be add 2 new sections to Vermont's Fair Employment Practices Act. The first one, as we've touched on, would restrict the use of non-compete agreements that prohibit individuals from competing with their former employer. And the second would restrict the use of stay or pay provisions that require an employee to repay certain costs to an employer when separating from employment. So just to walk through, the first one, section 1, would add section 495Q to the Fair Employment Practices Act. It includes in the definitions the agreement not to compete. And again, it defines what that would be. And again, this would be something that would seek to limit an employee's ability to work for another employer within a specified period of time in a particular geographical area or in a capacity similar to the employee's work that they're currently doing. And then it lists out what is not included in the agreement not to compete. So again, an agreement that would prohibit the disclosure of trade secrets or a non-disclosure agreement that protects confidential business information. You could ask your employees to sign that. That would not be considered an agreement not to compete. And in addition, it would allow employers to have a non-solicitation agreement with their employees. So in other words, you can't leave and then solicit clients or other employees to come join you at your new place. So subsection B, so on page 3, middle of page 3, line 7, the prohibition is on any agreement not to compete. And again, including an agreement not to compete contained within a contract would be just deemed void and unenforceable moving forward. And then there are some additional exceptions here. So again, if you own a business and you're looking to sell a business, then, reasonably, you might be asked to not set up something right next door. So that if you're selling all or substantially all of your ownership interest in a business or its operating assets or a subsidiary or division of a business, that would be exempt from this prohibition. Same thing for a partnership or a limited liability company. And then turning over onto page 4, this would provide that for existing agreements that are currently in effect, the employer would be required to notify each employee with whom they have an agreement not to compete, that the agreement is void and legally unenforceable. And then it just gives some direction that the notice will be in the form of a written individualized communication that would go to the employee or the former employee's last known address and email address. And then finally, subsection E, employee rights, would provide protection against retaliation and then would look at the penalty and enforcement provisions that currently are in the Fair Employment Practices Act. I apologize for my voice, which is starting to go. The second section would...
Any questions with respect to the non-compete provisions? Does everybody get that the way it's written, a non-compete says you can't go work for somebody else or do your work in whatever, this area or whatever. A non-disclosure agreement, which is not prohibited, that's not prohibited, means you can't use your knowledge that you have acquired here. If you can't take secrets, trade secrets with you, which could make it a little difficult to work in some cases. I mean, it's another way of hitting that cat.
Right, so section 2 would add subsection 495R to the to the Vermont Fair Employment Practices Act, and this is the stay or pay provisions. So just to follow up again, just a little bit of background. This request was largely modeled on the General Counsel memo from the National Labor Relations Board had issued a memo about these kinds of provisions. That memo, well, it was originally went into effect, but then it was back in August of last year, court down in Texas, said it was, unlawful or whatever. So it wasn't enforceable. And then with the new administration, the new general counsel at the National Labor Relations Board has rescinded the memo to do with stable pay provisions. So I did just want to circle back. You had asked whether or not there are employers that require people to pay back even if they're terminated involuntarily. Yes, that is something that's been happening nationally, and that was part of the reason that the NLRB's general counsel put out the memo about stable pay provisions. That there are situations where people are lured in, but these happen a lot more, I think, in lower paying jobs, but they're lured in, like, we're going to give you training, you know, come work for us. We've got these great employee benefits, and then they let them go. And then it's like, oh, by the way, now you owe us, you know, and often they will charge them much higher rates than whatever it costs them to provide that training. So there are abuses that have occurred nationally that these stable pay provisions have been an issue. So that's why the National Labor Relations Board had issued a general counsel memo on it, but that has been rescinded. So just
Also, by way of background, just because I know several of you asked about this before, remember, as a general rule, absent any legislation, assume no legislation, it's just up to the parties to put whatever agreement they put together in a contract. And they can put whatever they want in the contract if the the employer and the employee are willing to sign, you know, without even getting into the fact that usually the power lies with the employer, not with the employee. And the limitations on that, as a general matter, are pretty, you know, absent legislation. There's such a thing as a contract that's unconscionable, you know, a contract that's just so one-sided and so extreme. And courts sometimes will, if they see a situation that's really one-sided, they'll try to interpret the contract to favor the party who's the weaker party. But so all of these kinds of labor laws essentially are saying, but wait a minute, the state is going to say, that's some guardrails, some limits on what his contractual abilities are. That's what these things are.
So section 2, again, we're on page 4, line 13 has a definition describing what stable pay provisions are. And again, it's an agreement that requires the employee to pay the employer back if the employee separates from employment. And again, it can be for a variety of different reasons. This lists some of them: training repayment provisions, educational repayment contracts, quit fees, damage clauses, sign-on bonuses, and other types of cash payments. Subsection B on page 5, it'll be an unlawful employment practice for an employer to require an employee to pay the employer pursuant to a stable pay provision following an employee's separation from employment. But then in subsection C, as Representative Logan explained, there are a number of exceptions to that. So it won't be an unlawful employment practice if the employee voluntarily agrees to the provision in exchange for a benefit, the repayment amount is reasonable and doesn't exceed the cost to the employer of the benefit received by the employee. The repayment amount is specific and provided to the employee before the employee agrees to the provision. So the notice piece is important. The length of the stay period is also reasonable. And again, there are a number of factors there: the cost of the benefit bestowed, the value of the benefit to the employee, and whether the repayment amount decreases over time. And then that the repayment is not required if the employee is terminated without cause. So if you had one of these provisions, but then you let somebody go, they didn't voluntarily leave, they would not be required to pay that back.
So these are ands, right? In other words,
Right,
become an exception.
right. You would need,
All of the things 1 through 5 have to be the case.
right. So you can have them, but you have to comply with all of the subsections. On the final page, on page 6, again, it has that same notice requirement that if you currently have one of these agreements, that you provide notice to the employee or employee that it's void and unenforceable. And again, the same, no retaliation, retaliation protection that's currently in the Fair Employment Practices Act and penalty and enforcement provisions that are in the current act.
Any more questions by members of the committee? It's a Thank you. Magali, do we have, thank you so much, Sophie. So we've now walked through this bill and we've had an introduction and a walkthrough, and then we'll decide whether to take it up and take testimony or not. So thank you very much.
I don't think our next witness is here.
What?
I just emailed.
Okay. So our next bill
Thank you.
is the flood hazard bill. And as you remember, the bill was fairly simple. And then we asked Cameron to draft an alternative approach, which would allow a checkoff. And in other words, the bill as introduced simply took out, let me go back, started off with a requirement that sellers of real estate in their information that they provide buyers had to tell them whether the property had flooded, whether they had flood insurance, and whether it was one of the two top categories of likelihood of flooding in FEMA maps. We had some testimony that the FEMA maps were not available for parts of our state, or if they were available, that they were not available, that they were unclear. They were not digitized maps that you could overlay on the exact location of your property, but rather maps. They're, I think what they meant, they're called raster maps. They're just maps that have been photographed, if you will, old. And it was problematic. We had a discussion in which we asked whether we'd be willing, there was some way that someone could have a don't know,
Right.
unable to ascertain check box. And Cameron indicated that he would draft something like that. So what's supposed to happen right now is Cameron is supposed to tell us and walk us through his amendment. And when he shows up, he will.
Cameron's.
Right, I was gonna say it's not Cameron's amendment, but
Yeah. It's a committee amendment, I guess.
right?
Is Peter,
I saw him like
Yes,
in the hall.
I told him that it had been rescheduled for closer to 2:45.
okay,
I can,
yeah, I'd let him know because I'm not, you know when Cameron's supposed to be here?
I just emailed him, he's on his way and I'm about to post the amendment.
Okay. So this will be under March,
It will, yes.
yeah, in a minute. Yeah.
You're voluntary.
Okay, so it's on the web now. If you go to our page and you go to Documents and Handout tab, you will see Strike All Amendment Draft 1.1. And
Just under date.
it should
It's under the
be,
date, under the date.
just look at, go to just our page and then go to Documents and Handouts. And then go to Tuesday, March 25th. And then strike all amendment. By the way, while we're waiting for Cameron. So when we're done with these hearings, we want to talk a little bit about, just take a little time to talk about our floor presentation tomorrow. And you should have all received Cameron's couple of page summaries of, so, and you also should have received over the weekend from me the order, along with who you are by what your name is, your formal name. And, because I always forget that.
Thank you.
And,
Just know that
Oh,
you're
thanks.
not, you're still alive.
yes, I know that. And so we'll talk when we're through with that, just kind of how we're gonna handle it. We are, if you look at the calendar for tomorrow, the House calendar, we are on the calendar. I think you're the fourth of the hearings on the calendar. So, and that's after a committee of the whole. For those of you who are new, a committee of the whole is the whole House is there. It's kind of like a caucus, but it's a caucus of the whole. And it means that the rules are suspended. It's all of us, just like we were in a normal floor setting. But it's essentially the rules are suspended. It's more informal. It's a chance to provide information. And we use it usually to discuss the budget. Some huge bill like that, we do that. Hi, camera. Have a seat. You are on. We've received both electronic and we're live. We have received both electronic and written versions of the draft 1.1 of H106. And you are ready. Would you identify yourself to the world and take us through Brad? Absolutely.
Give me a brief moment.
Yes.
It's Zoom. All right. For the record, Cameron Wood, Office of Legislative Counsel. We are going to talk about H 106 and an amendment that I drafted. Try to accomplish the discussion of the committee the last we met, which I believe was back in March 14th. It is in that sharing is not turned on, so I just sent a request.
You should be able to. I've taken away your privileges, Cameron.
Well, might be good reason for that. Okay. Here's our H 106, an act relating to selling real property within a FEMA mapped flood hazard area. So if you all recall, and what I have here is the bill as introduced on the screen. You all recall the bill as introduced, it would be removing the requirements as part of the sale of real property for the seller to identify to the buyer whether the real property is located in a FEMA mapped special flood hazard area or a FEMA mapped moderate flood hazard area. And as we talked the last time, we really were centered on this subsection C and D about, what happens in the event that, an individual isn't able to ascertain whether the property is located in one of those maps. There are certain areas that aren't mapped. There are certain maps that, it may be difficult to determine where the property falls within the map, et cetera. That was kind of our conversation that we talked about last time. If you all remember, we also talked a little bit about this section 2 and 3 about the retroactive provisions of the bill as introduced. If you were to remove the requirements and make that retroactive, you still need to address the fact that it was law during a period in time and somebody could have a right against a seller in the event they were not provided the information that was required during the period of time in which the law was in effect. So those were some of the conversations that we were having last time. So I'm going to switch to the amendment now and talk about what this amendment will do. So as you can see, this is draft 1.1. It is a strike all amendment from the committee. And what I've done is we've kept section 1. As you can see, you're not striking the 1 and 2 anymore. So it will still be a requirement if this amendment were to pass and go into law. So we're moving to the page 2 here where the changes are. The changes are going to be in subsection D and subsection C. Subsection C is really language that I think it would probably be best to clean up. Subsection C is where the buyer can bring an action against the seller in the event they're not provided the information that's required. The language says currently a buyer who fails to receive the information can bring an action. Doesn't really make sense that way. Because a buyer can actively take steps not to receive the information if they so choose. So I just thought it best to clean it up here to say that if the seller fails to provide the information, the obligation's on the seller here to provide the information, then a buyer can bring an action. So that's just a little bit of cleanup there. Just want to make sure you're all aware of it. So now we're in D. Now this is really where the kind of substance of the amendment is. So here's where I've broken out subsection D into 2 subdivisions. So the D1 is all current law, and this is where, if you all remember, we talked about currently if a seller provides inaccurate or omits information, but they're doing it based on reliance of information that's provided to them, this is line 13, by a public body or a person with a professional license, this is a defense against a buyer bringing an action. Buyer sues the seller. You told me this wasn't in a FEMA mapped area. it actually is, and my house flooded, I have damages, I'm suing you for that. The seller can say, whoa, 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 I gave you the information that was provided to me by a public body. This is a defense, you can't sue me and recover damages under that circumstance. What we're adding here is an additional defense where, so it's a seller shall not be liable for damages under this section for any error, inaccuracy, or omission of any information required to be disclosed. Now we're in the sub 2. If the seller, after reasonable attempt to identify whether the location of the real property is within a FEMA mapped special or moderate flood hazard area, notifies the buyer that the seller cannot reasonably determine if the real property is located within a special or moderate flood hazard area, and the seller notifies the buyer of the requirements of subsection A of this section. So essentially what this is if a seller just can't determine, and they've made an attempt to determine whether it's in an area, they can notify the buyer, I can't determine whether or not this real property is within one of these areas. There's a requirement that I provide that information to you. I can't determine it. And as long as the seller would be able to demonstrate that in court, that they provided that information to the buyer, it would shield them from damages associated if a buyer decided to sue them later on down the road. Because of this, because we're not removing the requirement in subsection A, you no longer, from my perspective, you no longer need the subsection 2. I mean, you can, in theory, again, there is the possibility that there's an individual who wouldn't be able to use this because it doesn't exist under current statute. So
You're talking about effective date.
talking about the retroactive application and then the effective.
So it just says.
So right here, this just goes into effect on passage.
Okay.
It would be a new defense at the point in time it were that a seller could utilize. It's not something somebody would be able to rely on retroactively. But again, they do have the defense that already exists, which is if they're relying on information provided to them by a professional, the entity they're contracted with to sell their property who says, yeah, no, it's not in the FEMA map area, we'll look for you. They still have that defense already. So this would be new, effective on passage. Happy to answer any questions.
Questions? I guess I have a I just want to make sure I understand something. I think I'm okay with this, but I just want to make sure. There's no liability of the seller except for damage liability, right? Under this law, under the law to begin with. So if you exempt them from damage, you're exempting them from the requirement, right? Yeah, okay.
The only other thing here is if the information isn't provided and the buyer becomes aware of it, they could then cancel the sale before it goes through.
Right.
If you didn't provide me with the information, I did my own analysis and I found out that it is in a FEMA mapped area,
do that
I'm
anyway.
canceling the contract.
They can do that anyway.
That's the only other remedy under this section for failure to provide the information, is how I'll phrase it. Cancel the contract if it's hasn't been completed. And then subsequent to that, the only other remedy for a buyer is to sue for damages.
Right.
So,
Any further questions? Yes.
On D1, where it says professional license or special knowledge, what does special knowledge mean?
The way I would read it, how this works in reality, whether there's people out there that can offer this, I don't know, but it could be somebody who is holding themselves out as providing a professional service that isn't required to be licensed. So, I don't know to what extent that happens in the real estate business. I would potentially defer to others. But essentially, there are professions that operate in the state that are not required to be licensed, but they may require some sort of degree or special knowledge to operate. This typically happens every few years. You'll get a bill where there's a request to have some sort of entity or industry come under the Office of Professional Regulations jurisdiction and require them to be licensed by OPR, for example. So to what extent there are individuals out there in the real estate space operating without a license, I'd have to defer to others. But that's what it's intended to get at, the language anyway.
I can think of an example, it would be a zoning administrator. A zoning you talk to the ZA, they don't represent the public body, but they're just the zoning administrator. Or, or somebody like that, the chair of the planning commission, who says, well, of course you're not gonna find it in there, or something like that. Our whole town, we can't find the maps. I think that would probably be covered by such a person with special knowledge, who isn't licensed.
But it's loose.
Yeah, it is loose, but right, it has some flexibility to it. But
I mean,
people
it's
do
there to
here,
say, so like you as a seller can't say, well, I asked my neighbor.
yeah,
And my neighbor told me or wrote to me in an email that of course we're not mapped in the area. You wouldn't then be able to use that, unless you can demonstrate that your neighbor has some sort of special knowledge, right? And
Oh,
so
so
in
you would have to
that
demonstrate
instance, you
that.
could say, oh, well, my neighbor is the chair of the select board or the town clerk or, whatever, position. So I'm relying on that person because of their, position that they exist and the knowledge that they have. In that case, I think that would be a defense.
In those instances, would that person then be liable if there was some kind of discrepancy?
Not under the law, no.
Okay, okay.
any questions of Cameron, I'm gonna ask Peter to come up. Just Peter, you might want to just come up, identify yourself, and if you have anything to say about this, say it.
Scroll back to A and B.
Yes, sir.
Just. Yeah, 1, 2, 3, 4. I should. yeah.
Just no change there to A.
So there's no change there.
Yes, sir. Yield to you, sir. Thank you.
Hi, everybody. Peter Tucker for the Vermont Association of Realtors. I think this gets to the heart of what we're really trying to describe. That there are instances where, maps are so difficult to determine or unavailable. I mean, the unavailable ones I think are probably, not incredibly flooded areas, right? And when I looked at the map statewide, most of those are very small towns that probably have little real estate in them. But the maps that are old and really difficult to determine where properties lie on the map is been the challenge that we have. This on outward appearances seems to, allow us to have that answer of, geez, I cannot determine, whether I'm in the high flood hazard area or the medium flood hazard area. And that's my impression of this language. I think we would find that very favorable. It's been interesting for me because I jump back and forth between the form that we've actually created and used to try and help sellers delineate, where they're at. And the legal language that Cameron is much better at than I in terms of, how do you create that protection? This does appear to create that protection, would allow us to modify our forms. And, we want explanations of, why, you can't determine it or you're in a flood hazard area. It serves the buyers certainly. And, I think that going back to the beginning of, when we discussed material facts, buyer needs to understand before they make an offer on a property, what's their perceived value of the property and, or, do they even want to enter into a contract on the property based on, kind of the risks that are there. So, we want to see buyers protected. We just don't, we found that sellers are having incredible difficulty, providing the correct information And I think this gives us that flexibility to, you know, to really protect some sellers. I will say as a real estate professional, it is not our job to you know, to do this for the seller. The seller needs to make their determinations. You know, we can assist them, but, you know, we don't want to be responsible for the disclosure. It is ultimately on the seller, and that continues in the case here. So, along with the chair, I believe this works.
Questions, Peter, before we bring it back to us for discussion and possible vote?
Thank you.
Thank you, Peter.
And you have Chris Delia here from the bankers. I don't know if you had any additional comment.
Leave it to the chair.
Okay, very good. Thanks.
So thoughts on the committee? I think we should just, people should say what they think if they want to, and we should vote today if you're ready.
I'm ready to vote.
Thoughts of the committee on this?
We're not dealing anything with the retroactive in this, right?
This would simply be a new defense that would be
Loves it.
available after passing.
Perfect.
I'll just say, I'm happy with this because I think it strikes a balance between, first of all, it admits a reality. I personally, because I really care about, you know, my towns, Marshfield and Plainfield are at terrific risk of flooding from, if anything, Lord forbid, should happen to the dam, Molly's Falls Dam, they would disappear. But at any rate, I've seen what happens when flood contours, because there's every dam like that has an emergency management plan. The emergency management plan has to show what would happen if that happened and show the flood areas. You try to overlay the flood on the maps and you can't tell, you can see approximately, but you can't really tell if your property is gonna be flooded or not. Because these maps, a lot of them are just photographs of old maps. They are not digitized like we're used to. They can't be overlaid on tax maps or anything else. So I think that the problem that was presented to us, which is what do we do if there are no maps or you can't tell, is very real. On the other hand, I was worried because with climate change, the past is not exactly a good predictor of the future. And so the fact that it hasn't flooded before, imagine if you'd bought property just before, you know, 2 summers ago in May or June, excuse me, June is spring. You bought the property and then look what happens. So I think what this does, it alerts the buyer. I mean, if I saw checked, I don't know, I would ask my realtor, where is this? Why don't they know? You know, do I have to worry? And if they say this isn't anywhere near, I mean, you know, you're miles from flooding, well, that's no problem. But if it was, you know, their answer was ambiguous, I'd look at it more. And I just feel like that's all we could do. You know, all we could do is alert a buyer that there was something they ought to look at. And I feel that Ledge Council has done a good job here. That's my take.
Mhm.
I'll tell you what, are we ready to vote? Okay, clerk?
Are
I
we
make a
voting to
motion.
take it up?
We need
or
I
are we
keep
voting-
forgetting
I'm
that we need a
about-
motion.
I'm on it.
Do it.
All right. I make a motion to approve Draft. I need it, yeah.
1.1.
Draft 1.1
Of H1.
of H1Os.
It's on your.
Oh, it's in front of me. I make a motion to approve draft 1.1 of H106. Can I get a second?
Can I get a witness?
I will second.
All right, we have a second. We have a motion, we have
Friday.
a
Oh, right,
second.
it's on.
Would someone, or the clerk, please call the roll?
Representative Bartley, is she coming back?
She's absent, so.
Oh, okay,
That's me.
okay. Representative Burrows,
Aye.
Representative Charlton,
Yes.
Representative Dodge,
Yes.
Representative Dalton,
Yes.
Representative Howard votes yes. Representative Krasnow,
Yes.
Representative Lamont,
Yes.
Representative Parsons,
Yes.
Representative Pezzo,
Yes.
Representative Mahali,
Still trying to recover from the prior votes. Yes.
Excellent. 10. 0.
So the vote is 10-0-1. In terms of a reporter for this bill, Debbie, might you be interested in being a reporter for this bill?
A reporter? Is that when my name was mentioned?
The teacher calls on you.
What it means is that it means several things. One is we will send this bill to the drafting office, right? Or will you do? We'll send the bill to the drafting office. And
It does not need to go back to us, no. This has
It doesn't.
been, it has been edited. You simply need to take
send it
it.
to Nigel. So it's sent to Nigel, and indicate that you are the reporter for the bill and what the vote was. Then it will go on the notice calendar, I believe, tomorrow. It's a little late. I'm not sure whether it might go tomorrow, which would mean it would come onto the floor on Thursday. Unless the speaker, pushes it back because it's got the budget or whatever. But whenever it comes up for second reading, it's been through first reading because it was sent to us. And Cameron, do we report this as a strike all amendment?
Yes, sir.
Yeah, we would report it as a strike all amendment. So it would show on the notice calendar approved, recommended with amendment. And then you would, when it's up for second reading, like you saw today, you would stand up and you would be the reporter for the bill, and you'd get called on and you would say, here's what this bill does. And just summarize it. Are you available for that?
Sure.
Okay.
Get a star for that?
Sure, maybe two.
We have a lot of stars.
Yeah, I can give them
Maybe when we have our
committee dinner.
committee
I'd like
dinner,
the
we can buy an extra drink for it.
Trophies, awards.
Okay. So, I guess it's kind of, we haven't done this very much. Who does send the emails out here in this committee?
To whom?
Nigel, is it the
Whatever is
reporter?
reporter.
Okay,
reporter.
so
Yeah.
what I'll do is send you an email that summarizes it, and you can forward it to you can copy it, paste it, and send it to Nigel. I'll do that in just a minute. Okay, so now to proceed, we're just discussing bill presentation for tomorrow, 479, when we are on the floor. Of course, that's not necessarily the last thing we're discussing today. It's not. So the way it's, you should all have, and I just want to make sure you have a list of the order that it is, who the presenters are, what their formal name is, like I'm, Mahali, Representative Mahali of Callis, the representative from Callis. And what you want to do is, I would ask that each one of you, either now, because we're gonna adjourn pretty soon, either now or now would be good, or this evening, prepare your testimony in writing. And what I would suggest, but it's really up to you, is that I sent you all a brief memo that just had my thoughts about context setting, but that's just my thoughts. You can put whatever you want. And you would say section blank, but then what you want to do, and this is the hard little wrinkle. You've probably noticed that when people report on a bill, they reference the calendar for that day, because the bill's printed in the calendar for the day. So what you're going to need to do is just you start off by saying, I'm reporting on section 12, which you can find on today's calendar at page blank. And I would just leave it blank. And then tomorrow morning, you can look at the calendar and you can look at the page and find your section and say what it is. And then set the stage. And then I would just use Cameron's excellent summary. If you'd like to edit it because you feel he's been insufficiently eloquent, that's your section, you may do so. But I'd urge you to keep it short. People's, you know what it's like. People's attention span is short and for good reason. And then at the end, when you're done, you'd say, Madam Speaker, I would now like to yield the floor to, and then you look at the next person and you write their name down. And I would say that I am here and Cameron is available and other members are available here to talk to you about how to do this. If you have any doubts?
Can I,
Go, okay, yes, and yes.
I was just gonna simply say that, it's advisable to have your floor speech printed out.
Yes.
Yeah, I mean,
Leonora.
No school like an old, like the.
I always read
yeah,
that.
and there's people who are going,
I
what
always
happens if
read,
it
yeah.
doesn't work?
Always,
Yeah,
always.
right, or your cell phone,
And as you think of, if somebody asks you something, it's really nice to have the whole bill right in front of you
Mhm.
on paper so that you can, like, as you're hearing the question, you can kind of like,
Find it.
Yeah,
find.
I would just clip your section. If you do not know the answer, if you get a question, don't be argumentative in response if it's challenging. You heard today, just say, I don't, either say no, yes, or a little explanation. And if you have any doubts, your options are to ask Madam Speaker, can I yield the floor to me? Or you can say, could I ask for, do you see it? A brief recess for me to talk to the legislative council. And guess who is going to be sitting in one of the little
Oh
red chairs
my
up there?
gosh.
Yes. And then what happens is usually you, Cameron, and the person who's interrogating you get up there and talk for a few minutes until you get it straight.
That was what I was gonna.
You don't have to be a loner.
Aw.
Gail,
Completely forgot what I wanted to ask.
But yeah, that's what I was gonna add.
please add away.
What you said, just if you have any questions, those are two great options. Yield to the chair or ask for brief recess to confer with legislative council. Happens all the time, as you can see, even with chairs. As we said.
And you saw today, someone said, actually, you didn't know about that, or whatever. Yeah,
So if Ashley is out sick, if she's playing a big part in this.
She'll be back.
she'll be back.
She's
she'll
the
be-
type of person, she'll call
she'll be-
back.
She'll claw back. She may be snuffling and
Behave.
freezing.
Be hip as
If she is sick, she'll let me know and I'll cover. Or I'll ask somebody else to. Yeah,
So just looking at, oh, I'm sorry, I feel like there's something other.
No, go ahead. I'll go back.
Not that I think we need to talk forever and ever, but I just wonder whether you want us to give slightly, like even just a sentence or two about what, say, the down payment program, like, or do you want to just,
which section?
I think our names aren't on the section, so I'm just.
No, there's another page.
There's the memo I sent out that has.
But it looks like I'm section 6 of the HFA and the. first
Right,
gen and
right,
then
yeah,
down
okay. I mean, I don't think it's necessarily obvious from the language what it's
Right.
about.
Exactly.
So that's why I think setting the stage of saying the down payment assistance program is a way of giving someone a loan that's repayable eventually when the property's sold, that helps them with their down payment. Or the grant program is for first-time home buyers, first-generation home buyers. Like you said, a sentence or two.
Okay.
Unfortunately, I have to have this confirmed. I believe that that approach took the whole thing out.
Oh,
All right.
They did? Yeah. So
Okay.
it is not, but that is not our obligation. You can say at the end, if you want, I think it's fine. Put it out there and just say,
I can start out by saying, you can hear this, but you know that it is pointless.
well, or I would-
This is your cue to go to the bathroom.
I think you would say, it's at the end, it's actually at the end. I would
Right,
say,
the approach.
you can say, you're going to hear more about this in the appropriations event. Or you're going to hear that this program was not funded. Which is, I think, most unfortunate. Mary,
I think you may have said this before, but when you finished your presentation and you refer to the next person, it's not like I refer to Mary.
right?
It's the representative from Rollins City.
The member.
In the memo, it has that too.
Oh, it does. Oh,
Mhm.
Yeah, there's a couple things to look for. So there's a memo from our chair that has the assignments and who you're yielding to. And then today we also got the section by section summaries of each section from Cameron.
And Cameron's memo is a Word memo. So you can just cut and paste it however you want along. And you could put your introductory remarks and then at the end, I mean, in mine, I've written mine out. I have an introduction where I say, here's what this bill is all about generally, and housing is urgent. You've seen, just a sort of table setting. And then I say, I'd like to begin by yielding to the member from Fairfax who will speak to the bill's work, et cetera. That's her.
Just so you all are aware or are not, if you're not aware, the appropriations committee's amendment is, I think you might be talking about this in the morning, so wait, if you would rather. I'll just comment on the appropriations committee is recommending to substitute the House Ways and Means Committee report with their own recommendation. So procedurally, I had to phrase it that way to make it cleanest on the floor for how things will work. But if you remember, Ways and Means was putting a sunset on the tax credits,
Right.
removing the municipal 1%
STR.
tax. And appropriations was recommending to strip all of the appropriations out of the bill, including the tax credits, and also removing the 1% tax. So, but procedurally, how it will be happening on the floor is the appropriations committee, when they get to their report, after Ways and Means, appropriations will do their report, their
Ways and
recommendation.
Means do.
I believe that they would provide information on their recommendation.
Even though, so it'll be us, Ways and Means, it'll be like,
Teddy and Tiff.
yeah, and then Tiff will get up and say, we are proposing an amendment, which is to strike all of the Ways and Means amendment.
She probably won't phrase it that way. I haven't spoken with her yet, but it's not a strike all. It's a substitute amendment, which you can conceivably think of as a strike all.
Okay,
But it would be substituting Ways and Means Amendment with their amendment.
okay, so how's the vote gonna go?
So then my understanding is the body would vote first on whether to substitute Ways and Means Amendment with the amendment from appropriations. If that was approved, you would then vote on whether to adopt the recommendation from appropriations.
Right,
And then if that was approved, you would then vote whether
for
to.
third reading, whether to go to third
Yes.
reading for the whole thing as amended.
Yes.
Tomorrow morning, we will have straw polls on both amendments, right?
I think it is probably worth it to do both. Conceivably, the body could reject the appropriations recommendation to substitute, so.
You've seen how that works. What'll happen is after, I don't know how they're gonna handle this, but if Ways and Means report, Teddy gets up there, he reports. She'll call on me and say, and I'll say, we considered the amendment and found it favorable by a vote of X. Then after Tiff reports, I'll get asked the same thing. At some point, she's just gonna have to explain to everybody what the hell they're voting on, which isn't gonna be easy because it's a little different than usual. I can't tell you, I mean, I'm just saying, I'm not necessarily thrilled by the appropriations action because it, but I'm very aware of the dynamic. They had a tiny fraction of the money that we would have liked them to have to play with. And in addition, to be perfectly frank, I think they probably felt, and I'm just speaking what my impression is. Last year and the year before, we had 2 votes on the budget, which were divided by party. And that, what I was told, was rather unusual. That in the past, we had been able to reach a compromise where it was a bipartisan vote in favor of the budget. And this year, it was again a bipartisan vote. The budget was voted out by appropriations 11-0. Well, you don't get that without some serious heavy-duty compromises, which is my way of just saying, for me, I will vote yes on the straw poll, even though I'm not delighted by their action.
Right.
I'm just, I feel like they did their best, with what they had. And I will do that. So you don't have to love what they do in order to support it, although you can oppose it. You just have to take the straw vote, and we're going to do it at 9 a.m. promptly tomorrow. Because at 9:30, we're going to have Betsy Ann will grace us
Oh, yes.
to discuss just sort of what our obligations are with respect to the constitutional amendments. What's it called?
Oh, good. No, they're all
Prop 3. And there's no rush on it, but she'll be doing that at 9:30. So we'll have the straw vote at 9.
Okay.
Set my alarm.
And anybody who wants help, don't hesitate to contact me or contact,
I'm around.
yes. I
If
mean,
you'd rather.
yeah, just ask the experienced people here what to do. I think I have been part of the effort to report the budget. Something you're going to all go through tomorrow or the next day. And it's hard, it's hard to keep people's attention when you're dealing with, I mean, the budget bill.
Mm.
So you can spend, as my memory is, it took 2 hours. And our bill is, this bill is 192 pages long. Our bill is 40 pages long. I think that, you should try to keep your efforts to pretty short. Don't worry if it's too short,
Right.
just do it. And by everybody popping up, it'll make it less boring. I have to talk to you about how we're gonna do yours. I talked to,
Okay.
okay. So, because she's doing appropriations, a lot of appropriations, yeah.
All right.
But if your section has an appropriation in it, you can just say there was an appropriation. You'll hear from appropriations on it. You don't have to get into detail. Okay, any last questions?
Any last words?
Yeah, before we do the straw poll tomorrow, I just want to make sure I'm looking at the right
Yeah, I don't know.
amendments.
Yeah, I'm
Well,
not
what
sure
I
what
think
got
so,
through. Did
with
we
Ways
look
and Means, it's easy. It's on,
That one is, yeah.
If you'd like, I mean, I'm happy to make sure you have it. Give
okay,
it to Magali and.
Magali, and I think we should print them out and
And
then,
you'll walk us through it.
Happy to.
yeah.
I mean, when they come in.
Yeah, but the thing that's harder is the approach. The approach, the actual text of the amendment is like minimal. It's like a page. It's because all the work is in the budget. They just stripped everything having to do with appropriations, as they always do, out of our bill. And the actual is in the budget. And there has been work done by legislative council and by JFO. I haven't had a chance.
So you can look at their bill.
Yeah, I haven't had a chance to look at it yet. Is it side by side?
Yes, sir.
I can't figure
It's
out.
pretty good. I've got it right here. I've got it on my screen right now.
Yeah.
That's the one I'm trying to figure out. Where's it?
Okay, so there's a side by side that will allow you to actually see what did we put in our bill? How did it end up? It ain't pretty.
Well,
Where
it
is
depends
that?
on,
Sorry, where is that?
It's in a memo. That memo.
You have it. The committee doesn't have it.
So
Can you send it to Magali?
No idea
Provide
what made
to the
it, what
committee.
did.
Yeah,
I don't even.
essentially. Well, I'll tell you what. Would you just like to see it now?
I
Sure.
have the
You gotta go.
ish.
Okay, well, we'll do that tomorrow, but why don't we send it out to everybody now? But I can tell you very briefly. The bond bank got funded at half. The HFA middle income stuff got funded at half. VHIP was funded, but less, didn't get all its positions. I'm just summarizing. Universal Design got its 15K. There was a VHCB got $5 million total. And also its percentage of its ratio of how much its base was devoted to conservation was reduced and more to housing.
Since
In other
it's
words, it was
70-30.
60-40, now it's 70-30. The home share is in there,
That jives with.
Home share got 250.
235, yeah. But
What happened to Sash?
I don't know. No?
Sash got the axe.
Just your recommendation. I don't know what they get.
Okay.
I don't know what is in their other
Right.
requests, et cetera. So I mean, that just what was in your bill recommendation did not make it.
Except you, a lot of that corresponds with the Senate bill too. Like,
Well, some of it does. The Senate bill didn't have too
they didn't
much.
have anything for Sash.
Yeah.
They had
Hmm.
much reduced for VHFA. And they had much reduced for VHCP.
Right. So our bill is gonna go to the Senate. The Senate bill's coming over here. We're gonna go over the Senate bill on Wednesday, tomorrow morning. Yeah.
Action packed.
Yeah, at 10:30, what we'll do is we're gonna have Betsy in, and then at 10:30, we're gonna go through the Senate language, and Cameron will take us through and compare it to ours.
Before we report.
Yeah, all this will happen before, we don't go back on the floor till 1 o'clock. And you're gonna somehow manage your time so that you don't have to be at exactly the same moment on both floors,
Already working it out.
okay? And of course, we take priority over the Senate.
I will be in the House and not the Senate if there is a conflict.
Whoa, I don't want you to get you in trouble.
I like the sound of
I
that.
like it, but,
All right.
all right. Other questions, everybody? No questions?